Hi, and welcome to this webinar on the Property Law Act that came out in 2023. My name is Jeremy Stratton. I am the Legal Practice Director at NPR Law, Northern Property and Resumption Lawyers. I want to just give a shout out to everyone and also just acknowledge the fact that we're doing this webinar on Wednesday, the 5th of March 2025. And anyone who lives in Southeast Queensland knows that we are staring down the barrel of the tropical cyclone Alfred, which is going to make landfall any day now. And so I hope that everyone is safe and well. We're going to be doing more of these webinars as well, and might have more opportunities to ask questions. So thank you for your time. And I just wanted to make that point about the time we're doing it. And that's also relevant too, because what we're talking about today is a new Property Law Act for Queensland. And though the laws that have come into place and will come into effect later in the year will change over time. And before they all come into force on the 1st of August, and there'll be changes before then too. So I just want to date stamp this, the 5th of March, 2025. So let me talk a little about NPR Law. So we are specialists in property and resumption work. That means we do all things conveyancing, both residential and commercial. We help people do leases. We help people whose properties have been resumed by the government. And all of these areas are affected by the new Property Law Act. So back in 2023, the Queensland government passed this new act, and it comes into force on the 1st of August 2025. So everything I'm talking about comes into force on the 1st of August 2025. You need to be across what the changes are and how they'll affect you well before that. We have people watching this who are real estate agents, who are clients of ours, property owners, developers, all manner of people are watching this, and different parts will affect you in different ways. So let me go through the let me give you the state of play right now before the 1st of October 2025. So there are a number of acts that govern property law in Queensland. There's the Property Occupations Act, which governs how real estate agents engage with their clients. There's the Property Law Act, the current one. There's the Body Corporate and Community Management Act that regulates properties and strata titles. There's the Land Title Act. So that actually regulates the whole titles system that is the register of all properties that are owned in Queensland. And as I said before, there's also the Property Law Act. It's like the mother of all acts. It has all of the overarching and kind of covers everything together. So the new act passed in 2023 was based on recommendations made by professors at QUT. And they literally wrote the book, these professors, on REIQ contracts, and they wrote the REIQ contracts, or help write them, and the textbook that we rely upon to give us advice around this. So these are very, very important. So there's lots of different changes, little minor changes that have been made to the law, which I'll go through some of those. But the main things are the changes to the seller's disclosure. So let's talk about that. So I'm going to go through the main three things, but the first one is the mandatory seller's disclosure. So this is a new form, which I'm going to go through in a moment, and it applies to all properties sold within Queensland. There are a small number of exceptions to that, such as where you're selling to government. So that's relevant for when we're doing sales to the state government or local government for resumptions. Then this doesn't apply to that. But for most properties sold in Queensland, it will apply to. There is a prescribed form, which I'll go through in a moment, and you've got to attach documents to it. So let's go through the form. So last time I did one of these, I didn't have the actual form, but recently the government has released the form, and so I want to go through it as part of this call. So this is the seller's disclosure document. You'll see this is a Form 2 version 1, and it's effective from the 1st of August 2025. Do not, as a real estate agent, use this form before then. However, I would say starting in July, you need to start getting the information ready for this, and make sure that you're using the right version of the form. Because if we know one thing from the regulation of property in Queensland is they constantly change these forms, not constantly, but quite regularly update the forms and go through. So. There's and this is one. It's a bit like for those of you who are aware, under the body corporate legislation, you've got to provide disclosure about the body corporate. And this is like that. So you've got to sign it. The seller has to sign it and give it to the buyer before they enter into the contract. And we can talk about the mechanics of that. But things like it's got some just generic statements that people need to be aware of these other things, especially relevant right now. As I said, we're recording this in March 2025. And we're about to go into a flood event. Let's face it, Southeast Queensland's about to do that. So you need to be aware of that, and people buying property need to be aware of flooding history. And all these things are things that you're going to have to that aren't disclosed. You're going to have to find out about. So quite simply, the details of the property go in here: the seller's name, the property's address, the lot and plan description. If it's part of a body corporate, then or it's a body corporate or BUGTA, which is the old body corporate system, then you need to tick that. Now, this is where we start to get to documents that need to be attached. And the first one is a title search. So the title search shows where the property is registered and that it's registered and who's the owner. In Queensland, the property search is the document that is the golden rule about who owns what. It's called indefeasibility of title. So you've got to show that. You've got to have a copy of the plan. So every property in Queensland is lot something. So lot one on SP 123456 or RP 123456. That's a registered plan that is registered and actually identifies the lot that's being sold. You need to provide a copy of that. In the legislation, as I understand it, registered encumbrances. So these are things like that are registered on title that are going to transfer with the lease. Sorry, with the property. They, as I was understood it, they need to be provided as well. This form doesn't actually say that, so that will be an interesting change that we'll need to double check. But things like easements need to be listed and potentially provided here. You need to, this gives a warning that the buyer needs to also make their own inquiries about it. But yeah, ordinarily you'd get copies of those. So leases, registered leases, statutory covenants and easements. Mortgages, you don't need to provide a copy of the registered mortgage if it's been released at settlement, which is, let's face it, 9,999 times out of 10,000 that's happening. Probably more than that. Probably one in a million times that you wouldn't do that. You would just need to provide copies of those. We'll provide another update about exactly what needs to be provided as documents here. But I think good practice would be to include copies of these documents as well. So then that's registered encumbrances. So that's registered on title. Then in property, there are a bunch of unregistered encumbrances that exclude statutory encumbrances. So there's also statutory encumbrances, which we'll come to in a moment. So these are things that may not be registered on the title. So unregistered leases, you may have a property that has more than one registered lease. So you provide a schedule and provide all the same information here. Copies of the leases need to be provided, and all this information. Importantly, if there's any unregistered oral agreements, so this might be that you do have someone occupying your property under a verbal lease that isn't in writing, which I wouldn't recommend anyway, but it does happen. And so you need to give the details of that. Statutory encumbrances are things like what you find on a dial before you dig search. So these are things that might be a water pipe or a sewage pipe that goes through your property that services other properties. They're not usually registered on title, but they are statutory easements in the sense that they've got to be there. So you need to give a description of what they are, a copy of the plan showing the location, and a copy of the actual documentation as well that you can get. If you're subject to a residential tenancy, you need to give a copy of the agreement as part of this disclosure. These things are really, really important. My belief in these things, it's always better to be safe than sorry. And if you're not sure, one, you can ask me. Two, if you really want to be cautious, just provide the document anyway, because you can't over disclose when someone's buying a property. So then let's talk about part three. Part three is land use planning and environment. So you've got to provide the zoning information. You've got to make sure that if there's any resumption proposed, that you're disclosing that. That's something that you should disclose anyway, but you've got to be in that. Then you've got contamination, environmental protection. You've got to disclose all that information about trees, heritage, and flooding. Some of this information is currently in the contract. As I understand it, the proposal is to come out with one standard contract for all types of properties. And as I understand it, part of the purpose of this form is to take these questions out of the contract, the various contracts, because we have residential contracts in a body corporate, we have commercial contracts in a body corporate. There's lots of different versions, and put it all in here. And then the flooding, which obviously is very relevant. Make sure that you're disclosing the information. I just had a person yesterday call me. I won't reveal any names, who bought a property in the Moreton Bay area a couple of years ago. Actually, last year they settled, and they were told that it didn't flood. And with the impending cyclone coming, a bunch of her neighbors have been able to say, geez, are you okay? This place floods, and provided evidence that that's the case. So, make sure that you're disclosing that. And we'll people have that information because you can, if you mislead, actually be sued for misleading and deceptive conduct. So just be mindful of that. All right. Vegetation habitat. So that's something that people need to search for. That's all publicly available information, and the like. So the next one is buildings and structures. So again, a lot of this is in like the residential contract and the body corporate residential contract. As I understand, it's been moved out of there and into here. So what I'd say is, just got to answer these questions. Swimming pools, unlicensed building work, notices and orders under the Building Act, all the stuff is self-explanatory. What you're going to have to do as an agent is ask the property owner for this information. There is some talk about that the government wants us, the lawyers, to draft these documents. We'll see what happens there. But that's something we're quite prepared to do. There'll be a bit of information that goes into it, and I would think that you'd want this signed as soon as you could from when you're instructed or appointed to sell the property, so that you give all this information. Building energy efficiency certificate. This is for large buildings only. I wouldn't stress about that too much, but if you're selling one that's that large, then they're going to need the building energy efficiency certificate. Asbestos, it's a standard warning in there about asbestos. The next one is rates and services. So here you've got to put in the information about what rates are being charged on the property and what the water consumption is. And you've got to provide copies of the notices that they've received. This is really important. This is one of the key changes, is they want this information provided at the time that someone enters into the contract. And this one is for buildings that are in part of a body corporate. And basically, to go through and answer these questions. So if it is yes, obviously, provide a copy of the current community management statement. Sometimes what's registered on titles may not be binding, and so you need to make sure that you've got the most up-to-date one. You've got to make sure that you get the body corporate certificate. So this comes from a body corporate manager. So you've got to get that with all the information about the insurances and the rates and everything going to be charged there too. And there's a different one for the old, so there's Building Units and Group Title Act for the buildings that are still on that. And then it just needs to be signed by the seller. And just importantly, I said this before, it needs to be signed by the seller before it's given to the buyer. So all this information needs to be there. So as I said, I recommend that when you're getting appointed, that you actually get this form signed at that time. Now, you'll need to check before you go giving it to a buyer that the information hasn't changed or there hasn't been a new rates notice issued or anything like that, but it'd be good practice, or at least to have a draft ready to go. And you would have noticed at the bottom of that form too, the buyer has to sign that too. So you need, as part of the signing process, you need the buyer to also sign the document. So if you've got any questions around that, please get in touch with us. But it's a really important form that we make sure that we get right going forward. All right, so that's the main thing I wanted to talk about in today's webinar, but I do want to go through some of the other changes that are coming in. So there's changes to leases. So we've at the moment, and this doesn't actually change, but we've got some leases that are governed by the Retail Shop Leases Act, and they have higher regulation than the Property Law Act, the 1974 one, the one that's been replaced. These changes that I'm going to go through apply to leases that aren't part of the Retail Shop Leases Act, so they're not retail shops. And at the moment are entered into after the 1st of August 2025. So there will be transitional provisions, and there will be some changes around what applies to when, but just work on the basis that the old rules apply to old leases and the new rules apply to leases that are entered into after the 1st of August 2025. If you are unsure, please come and see us because we need to make sure that we're getting this right for you. So assignment of leases. There's some now strict rules about where if someone requests an assignment of lease, you've got a month to consider the consent. Failure to do so means that the tenant can apply to court, but you've still got to provide all the information that's required. Basically, they're just trying to stop tenants or landlords from just delaying the whole process. Hopefully this doesn't go to court because it seems like a bit of a waste of money to instruct lawyers to do that. And hopefully it gives everyone a bit of a kick up the pants to do their job properly here. But importantly, that's an important change. The most important change here, though, is that under a commercial lease at the moment, if you have someone who's signed a personal guarantee, and you assign the lease to another party, and then they assign the lease to another party, and they assign the lease to another party. That original guarantor and that original tenant can be liable all the way down until the lease expires. That can be 10, 20 years down the case. That has now changed so that only the first assignment can the guarantor or the tenant be liable. So that can't go past that one assignment. If that tenant then chooses to assign it to another person, then that person, the original owner of the business, can't be liable. So that's an important breach. Sorry, important change. I'm reading my notes and I read breach. Breach of lease. Let's talk about that. So notice is still required. You've also got to serve it on everyone related to that lease on the title. So sometimes a tenant might have a mortgage registered over the title, or there might be receivers. You've also got to serve it on any guarantors, otherwise it won't be valid. And if there's any sublessees, you've got to serve it on them. All of those people can apply for relief against forfeiture if they think that you haven't done the right thing. But it is an important thing to notice. If you believe reasonably that the tenant has left the premises, then you do not have to give them any notice anymore. You can go and retake possession. I would be very, very cautious on this. I would be making very comprehensive file notes, and we all carry around one of these in our pockets, a smartphone of some sort. Straight then it's like loses the blue. And you want to make sure that you take videos and photos of everything that happens. And the last one is the rules around lease renewal. So the rules around where a landlord can say no to a lease renewal have been tightened up. I'm not going to go through all of the rule changes here on this because they're really finicky, and I would say that you need to talk to us or your lawyer about the specific circumstances before we give you advice there. All right. So other changes. There's only some other minor changes. The first one is deeds. So I think one of the good things that came out of COVID and the rule changes around that was that the legal profession embraced electronic signing more than ever before. And that is being continued with this new act. So it was transitional, it was temporary legislation. It's now going to be permanent. So a deed is an agreement that basically is signed because there's no actual money changing hands. And you used to have 12 years to enforce that, you go to court. Now you have 6 years. And they've also changed so that to make it clear that guarantees and indemnities can be signed electronically as well. Easements. So there was a rule or an ambiguity, I should say, that some covenants in the lease wouldn't bind people who didn't sign the lease but might have taken on the property in the future. We're not going to go into the complexities of that. Just know that there was. That has now been changed so that when there's an easement on title, that is fully binding on all parties going through. And the last change, which I think is a really good change, is installment contracts. So installment contracts, these are contracts that you enter into where you might pay a deposit greater than 10% for just a house and land. If it's an off-the-plan contract or development contract, you can take up to 20%. But there's there's this rule that says that if there's a payment under a contract that is not a deposit or the purchase price, or the balance purchase price of settlement, then the contract will be an installment contract, which gives a buyer a bunch of different rights. So one of these is a non-refundable deposit. So say an amount of 5%, that is non-refundable in any circumstances on the buyer, or by the buyer onto to give to the seller. So whether or not they terminate for any reason, they get that money. That actually makes the contract an installment contract, and it's very clear from the new legislation that it is. So I think that's good. I think that's just really securing the rules as they were before. But these are changes which are necessary because of what is it, 5 decades of law changes that come in. So I've been through the changes, and if you've got any questions, please get in touch with us. So you've got our contact details, NPR Law. You can email team@NPR Law, or you can give us a call on 07 3555 6333. And we'd love to hear from you with any questions you've got. These changes are coming in. We can't change them. They are coming in. And so if you've got any questions or need any help around it, please get in contact. We'd love to help you out. And if you need anything else, please reach out. Have an awesome day. Bye.